Hi, my name is Andrew Koulis, and I'm an attorney with the law office of Robert J. Koulis, PA. And oftentimes I meet with a married couple who are wondering, how does Medicaid affect them if something happens to them? And the answer to that really depends more on the circumstances than anything else, because it'll depend on whether one spouse is in a nursing home or both spouses might be in a nursing home. So I'll try and address those questions. The most common circumstances where you have one spouse in a nursing home and one that's not. And the way that works with a married couple is they look at the amount of income that they have and they look at the amount of assets that they have. Now, there is an income limit for the person that's in the nursing home. And right now, that income in 2015 is $2,000 per month. If the person in the nursing home makes more than $2,000 per month, then there are other planning things that need to be done to let them qualify. If they're under the $2,000 per month, then they're okay, and they look at the income of the spouse that's not in a nursing home just to determine if they make enough, because they're supposed to make a minimum level at least, and if their minimum level, if their amount they're making is not the minimum level, they do get some of the other spouse's income to make up that shortfall. Now, they do also look at the amount of assets that a married couple has when trying to qualify for Medicaid. And the person that's in the nursing home does have a limit of $2,000 on assets as well. So it applies to income, but it also applies to the amount of assets that they have. So in most cases, the spouse in the nursing home transfers their interest in any joint assets to the spouse that's outside of the nursing home. Now, there is a limit on the amount of assets the spouse outside the nursing home can have as well. And that limit is right now, and once again in 2015, is about $117,000. And what that means is that the spouse that's not in a nursing home can have bank accounts, investments, life insurance with cash value, a lot of different types of assets, and they have a limit of about $117,000 to allow the other person to still qualify. Now, when determining that limit, they do not count the value of your home in Florida, so your home is an exempt asset. They also don't count the automobile that you drive, and you're allowed to have a few other things like irrevocable burial plots. But basically what they're looking at are checking, savings, CDs, investment accounts. That's what they're looking at to determine how much you have in assets. So what happens with a married couple depends on those circumstances. Now, occasionally I do have a situation where I do have both spouses that are actually in a nursing home. And under those circumstances, the asset limit changes actually from $117,000 to $3,000. So it's much harder to plan in a circumstance like that. Still, the home is an exempt asset. The automobile, if there is one, is still an exempt asset. But basically, they are looking at everything else once again. The income limit stays the same for a married couple if they're both in there, where each can have up to $2,000, but the asset limit is what changes. Thank you very much.